Good afternoon, folks. Now, this is discussion B. We're discussing, can nursing homes pursue family members for unpaid bills? Okay, so we're going to dig into that for B this afternoon. Please join me for today's B. Here we go. Short answer, yes. In many states, including Pennsylvania, a nursing home can pursue family members for a resident's unpaid bills, even if the family never signed the admission contract. The mechanism is usually filial responsibility laws combined with aggressive debt collection practices and gaps in Medicaid coverage. Can a nursing home pursue family members for unpaid bills? When a nursing home resident accumulates unpaid bills, families often assume the debt belongs to society, to the resident, or to Medicaid. But in several states, including Pennsylvania, the legal and financial reality is far more complicated. Under certain circumstances, a nursing home can pursue family members, most commonly adult children, for the cost of a parent's care. This possibility arises from a mix of historical statutes, modern financial pressures, and the structure of long-term care financing in the United States. The legal foundation filial responsibility laws. Filial responsibility laws date back to centuries and were originally designed to prevent indigent elders from becoming public charges. Today, about half of the U.S. States still have these laws on the books. Most are rarely enforced, but a few states, including Pennsylvania, have seen a resurgence in their use. Pennsylvania's statute allows a nursing home to sue an adult child for the cost of a parent's care if the parent is indigent and the child has the ability to pay. The most widely cited case, Healthcare and Retirement Corp versus Pizza, affirmed that a facility may pursue a child directly even when their family member exits, and even when Medicaid eligibility is un, unresolved. The court did not require the child to have signed any financial guarantee. This means that Pennsylvania, the legal pathway exits for a nursing homes for a nursing home to file suit against a family member for tens of thousands of dollars in unpaid care. Why nursing homes use these laws? The enforcement of FEL law. FEL of responsibility laws is driven by legal tradition and more by the economics of long-term care. Nursing homes operate on thin margins, and Medicaid, while the primary payer for long-term care, reimburses facilities at rates even below the actual cost of care. When a resident's Medicaid application is denied, or penalized due to asset transfers, the facility may be left with months of unpaid bills. In this context, filial responsibility becomes a collection tool. Facilities may use it to persuade families into resolving Medicaid issues, paying privately, or negotiating payment plans. In some cases, they pursue litigation. How the process typically unfolds. Although the idea of being sued for a parent's nursing home bill is alarming, the process usually follows predictable steps: billing and internal collection, statements, calls, and attempts to clarify payer sources, Medicaid review, facilities assess eligibility denials or penalty periods, external collections. Accounts may be sent to third-party collectors. Legal action. Attorneys evaluate whether a child has the ability to pay. Court determination. Judges assess indigenous financial capacity and statutory exceptions. This step-by-step pathway is why families often feel burdened, feel blindsided. The debt moves from routine billing to legal action without requiring the family to have signed anything. Ethical and policy debates. The use of filial responsibility laws raises profound ethical questions. Critics argue that these laws punish families for systematic failures in long term care, financing, Medicaid's complexity, the 5-year look back period, and chronic underfunding create situations where families are held liable for bureaucratic delays or honest mistakes. Supporters contend that facilities must have recourse when they provide care without payment, and that filial responsibility law encourages families to participate in planning and avoid improper asset transfers. The debate reflects broader tensions in American long-term care policy. Who should bear the cost of aging? Families, states, or federal government? Practical implications for families. For families navigating nursing home care, the responsibility of liability means they must be proactive. Early Medicaid applications, careful documentation, and consultation with an elder law attorney can prevent gaps in coverage that expose families to risk. Understanding the law in one state is essential. Families should also be aware that nursing homes cannot simply assign responsibility to a child through admission paperwork unless the child voluntary, voluntarily signs as a guarantor. Filial responsibility is a statutory, not contractual. Yes, nursing homes can pursue families, family members for unpaid bills, but only under specific legal conditions and only in certain states. In places like Pennsylvania, Phil Lee responsibility laws give facilities a powerful tool to recover cost when Medicaid coverage falters. The result is a system where families may unexpectedly find themselves entangled in debt collection or litigation for a parent's care. This reality underscores the need for clearer policy, stronger consumer protections, and more sustainable long term care financing system. Until then, families must navigate a landscape where the financial obligation of aging can extend beyond the individual receiving care. Takeaway: Pennsylvania's L support law is relic, a relic with teeth, a statute most families have never heard of until a nursing home sues it to uses it to sue an adult child for parents' unpaid bill in a state where long-term care financing is strained. This law has become a quiet but consequential pressure point, exposing families to financial liability for systematic failures they did not create. The cruel arithmetic of aging. Why Pennsylvania's Phil support law must change. Pennsylvania is one of the fewest states where where an adult child will be sued personally, directly, and for staggering sums because a parent needed nursing home care they could not afford. The mechanism is the state's Phil support law, a statute that predates Social Security, Medicare, Medicaid, and the modern long term care system. It was written for a world in which families, not governments, were expected to shoulder the burden of aging. That world is gone. The law is not. And its consequences are becoming harder to ignore. A law out of step with reality. The the L support statute 23 PACS is the number of that statute is 4603, allows nursing homes to pursue adult children for a parent's unpaid care costs if the parent is indigent and the child has the ability to pay. On paper, it reads like a moral nudge. Families should care for their families should care for their own. In in practice, it is not it is not it is a blunt debt collection tool. The most famous example, healthcare and Retirement Corporation versus Pizza involved a son ordered to pay nearly 100,000 for his mother's nursing home bill. He had not signed the admission contract. He had not mismanaged her finances. He had not caused the debt. Yet the court ruled that the facility could choose any child to sue regardless of fairness or family dynamics. This is not this is not a theoretical risk. It is a precedent, one that nursing homes and their attorneys know well. And because the statute is civil, not criminal, the burden of proof is low. A facility need only show indigenous and, and ability to pay. The law does not require the court to consider estrangement, caregiving, history, or the emotional realities of family life. The real problem, a a system that fails families. Pennsylvania's long-term care system is under immense strain. Medicaid, the primary payer for nursing home care, reimburses facilities below the actual cost of providing that care. The gap between what Medicaid pays and what care costs is not a crack, it's a canyon. When Medicaid applications are delayed, denied, penalized due to asset transfers, or incomplete due to missing documentation, nursing homes are left with months of unpaid bills. Families often do not know this until the balance is already enormous. Philly L support laws are not about moral moral morality. They are about math. Facilities use Facilities use the statute because the financial gap keeps widening, and suing an adult child is sometimes the only way to recover cost. The law becomes a pressure valve for a system that cannot sustain itself. Why this law is ethically troubling. Pennsylvania's L support law raises profound questions about fairness, responsibility, and the obligations of adult children. It punishes families for bureaucratic delays. A missing bank statement in a Medicaid application can trigger months of private pay charges. It ignores families' complexity, entangled children, caregivers already stretched thin, and those with limited means can all be targeted. It creates unequal vulnerability. Middle income families, not wealthy ones, bear the brunt. It shifts the systematic cost onto individuals. Nursing home care is a public policy problem, not a private debt issue. Most troubling, the law assumes that families can absorb the financial shock of long term care. Many cannot. The average nursing home bill in Pennsylvania exceeds $12,000 per month. Few few households can withstand even a short period of private pay charges. The human impact. Imagine being sued for $60,000 because your mother's Medicaid application was delayed. Imagine being held liable for a father's care, even though you were never consulted about his placement. Imagine being chosen arbitrarily because you were the child with the highest income. These are not hypotheticals, they are real cases elder law attorneys see every year. The emotional toll is immense. Families already navigating grief, guilt, and the complexity of caregiving suddenly face litigation, wage garnishment, and financial ruin. Adult children who have spent years caring for a parent at home can find themselves sued for the final months of institutional care they did not choose. This is not how a compassionate society should treat people caring for aging parents. What Pennsylvania should do. Pennsylvania has a choice. Continue enforcing a statute from another era or modernize its approach to long term care financing. A human policy would include repealing or limiting federal support liability to cases of inter- international asset hiding or fraud, strengthening Medicaid processing timelines so families are not penalized for administrative delays, increasing Medicaid reimbursement rates to reduce the financial desperation driving facilities to sue families, create clearer consumer protections around nursing home billing and admission paperwork, require facilities to exhaust all payers' avenues before pursuing family members. Okay. Next page, guys. Pennsylvania cannot solve the long-term care crisis with lawsuits against adult children. It must address the structural issues that make those lawsuits attractive to facilities. Aging should not be a legal trap. The filial support law survives because it is obscure, old, and convenient for institutions that need leverage, but its continued use reflects a deeper failure. Pennsylvania has not yet reconciled the realities of modern aging with the policies that govern long term care. Families should not be punished for doing their best in a system designed to confuse them. Nursing homes should not rely on litigation to stay solvent, and adults children should not fear that parents' illness could bankrupt them. Pennsylvania's filial support law is a relic. It is time to retire. Okay, that is B for you. I'm going to take a little break and I'll be back on with C shortly. For now, Gator Wellness. Take care, folks.